Hello, friends. I welcome you all to this session of Indian Evidence Act, and today we will be studying Section 147 and Section 148. These are related to cross examination, and basically, Section 147 to 152 lays down various rules against aggressive cross examination so that cross examination is not done in a manner that the witness is harassed. So, what section 147 says is that when the witness to be compelled to answer, witness when when the court will compel the witness to answer it, no matter the effect of it would be positive or negative on him. So this says that if any such question relates to matter relevant to the suit or proceeding, the provisions of section 132 shall apply thereto. That is, in case the question is relevant, then the witness may be or witness will be compelled to answer it, no matter it may incriminate him. Now, section 147 provides that when witness can be compelled to answer, and as we have seen in section 146, that in cross examination, witness can be asked questions which are related to his position in life, veracity, and character. Now, in these cases, if the question relates to a relevant fact, then witness will be compelled to answer, no matter that the answers may incriminate him. But in that case, section 132 will apply. On the basis of the reply given to by the witness, he cannot be subjected to any prosecution. So that is what is section 147, that witness can be compelled to answer in case the question put to him is relevant. But in that case, section 132 will apply. That is, it would not make him a subject to prosecution because of the answers given by him. Next is section 148. Now, as section 148, you can see that court to decide when questions shall be asked and when witness compelled to answer. In this case, it has made certain, like it is given the court has been given the power as to decide that when the question will be asked or what type of questions will be asked and when he can be compelled to answer. Now, this we can understand by a simple chart that in a cross examination. So, this is related to a cross examination. So, when cross examination is going on and the question is otherwise irrelevant, it is not relevant to the fact in issue or relevant fact, but the question is such that it would expose the witness character, then in that case it is up to the discretion of court. Court is to decide, and court has got now three options. One is court can compel the witness to answer it. Second is that court may say that no, witness is not cannot be compelled or will not be compelled to answer it. And third option is that court can warn the witness that he is not bound to answer it. Now, how the court is to decide that whether he has to compel or whether he has not to compel or whether he has to warn, this would depend that court will decide whether the question is proper or whether the question is improper. Now, proper questions are those questions which would seriously affect the court's opinion as to credibility of witness. That is, if these questions are answered, then the credibility of witness will come into question. Seriously, that too. Then that is a proper question, and court will then compel him to answer it. And even if then he refuses it, then the court can make a presumption that had he given the answer, it would be unfavorable to the witness. Now, what are improper questions? Improper questions are questions which are very remote or which would very slightly affect the credibility of witness, or there is a great disproportion between the imputation that it will give to the witness and the importance of that evidence. That is, the harm which it will cause to the reputation of the witness will be very large as compared to the evidence which it will give in as the importance of the evidence in that particular case. So if this disproportion exists, then it would be improper question. So improper questions where it would very slightly affect the credibility or would not affect the credibility, or in case the importance there is a great disproportion between the imputation that would be attached and the evidence that will be given. So uh, and then the court decides that the question is proper, then in that case, the court will ask or compel the witness to answer it, and still if the witness refuses, then court can draw unfavorable inference with respect to the witness. So this is what is section 148, and there is why this discretion has been given to the court, that the court to decide when questions will be asked and when witness will be compelled to given to answer it, because as has been stated in the state of Punjab versus Gurmeet Singh's case, so as to ensure that cross examination is not made a means of harassment or humiliation to the witness, so that witness may freely come on their own to the court and depose before it. So that is what is section 148, that in a cross examination, if the question is irrelevant but exposes the character, then it is discretion of the court, and in deciding it, the court may compel the witness to answer it, or it may not compel, or it may give warning. But while deciding it, it will see whether the question is proper or whether it is improper. Proper question would affect the credibility of the witness. Improper would not affect the credibility of importance, credibility of witness, and it would not be so important to the case. And if still it is proper and the court asks him to answer it and there is refusal, then court can draw unfavorable inference with respect to the witness. Thank you, friends. That's all for today.